One of the most misunderstood requirements relate to layoffs that have been implemented in our pandemic era since last March. Now that it's clear that the pandemic may continue into the summer, what do employers need to bear in mind regarding layoffs and leaves, and why do they need to make these considerations?
Well, Seth, given that so many employers have had to lay employees off during the pandemic, it's crucial for them to know that there are temporary rules that apply, what these rules are, and that these rules will no longer apply soon. Employers who have laid employees off need to start planning for when the temporary rules end. Otherwise, they might lay employees off for longer than they're allowed to and effectively terminate their employment, in which case the employees can demand their termination entitlements. Before we dive in, it's important to remember that Ontario created a new job protected leave in March 2020 called the Infectious Disease Emergency Leave, or IDEL. This leave is available to employees who can't work for a variety of reasons related to COVID-19. Then, in May 2020, Ontario created a new regulation which substantially changed the rules for layoffs and leaves that apply to non-unionized employers during the pandemic, and which also appeared to temporarily change the law of constructive dismissal. Under the regulation, where an employer reduces or eliminates an employee's hours or wages for reasons related to COVID-19, it does not count as a layoff or constructive dismissal under the Employment Standards Act. Instead, the employee is considered to be on an IDEL. So normally, if an employer lays an employee off and didn't reserve the right to do so in an employment agreement, it's considered constructive dismissal. That means that the employee is entitled to treat the layoff as a termination of employment and to receive their termination entitlements. Unfortunately, late last month, an Ontario court decided that the new regulation actually does not prevent employees in those circumstances from successfully claiming constructive dismissal under the common law. On the other hand, and more positively for employers, because employees are legally considered to be on an IDEL and not laid off, the clock won't start ticking for the normal layoff rules under the Employment Standards Act while the regulation remains in effect. So normally, employers can lay employees off for up to 13 weeks, unless they continue the employee's benefits during the layoff, in which case the employees can be laid off for up to 35 weeks. Currently, the regulation is set to end on July 4th, 2021, at which point the normal layoff rules will apply again. So, unless the temporary rules are extended, the latest that employers will be allowed to keep employees on layoff is October 3rd, 2021, unless the employees continued receiving benefits, in which case they can be laid off until no later than March 6, 2022. As a result, employers should mark their calendars and begin to plan accordingly.